Introduction to the General Theory of Law and Marxism by Evgeny Branislavovic Pashukanis by Dragan Milovanovic. Introduction. Evgeny Branislavovic Pashukanis was at center stage in the development of Marxist law during the highly creative and challenging historical period of 1917 to 1937 in Russia. Pashukanis was perhaps the most significant figure to develop a fresh new Marxist perspective that was to have a dramatic impact in the sociology of law for many years. Although he was, quote, withered away by the Stalin purges in early 1937, his writings were expunged from the law universities in the developing Stalinist state by Andrei Vyshinsky. Pashukanis nevertheless left a legacy which gained a new momentum in the late 1970s. Apart from Pashukanis's activist political interventions in molding the legal landscape in post-revolutionary Russia, his so-called commodity exchange theory of law spearheaded a perspective that traced the form of law not to class interests but to capital logic itself, a logic to which both rich and poor were enslaved. Pashukanis's later critics, to which he gradually deferred more and more, argue that he had omitted the nature of Soviet law during the, quote, transition period of the dictatorship of the proletariat. But up until his death, Pashukanis continued to argue for the ideal of the withering away of the state, law, and the juridic subject. Pashukanis eventually arrived at a position contrary to Stalin, who was attempting to consolidate and strengthen the state apparatus under the name of the dictatorship of the proletariat. Needless to say, Pashukanis met his fate in January 1937 when he was branded an enemy of the revolution. His works were subsequently taken off the shelves, and his ideas were subjected to a one-sided critique led by Vyshinsky. However, in 1954, Pashukanis was, quote, rehabilitated by the Soviets and restored to an acceptable position in the historical development of Marxist law. In Europe and North America, it was not until the late 1970s that a number of legal theorists rediscovered Pashukanis's work, subjecting it to a careful critical analysis, and realized that he offered an alternative to the traditional Marxist interpretations that saw law simply and purely as tied to class interests of domination. By the mid-1980s, the instrumental Marxist perspective, which was in vogue in Marxist sociology, criminology, politics, and economics, was to give way, due to a significant extent to Pashukanis's insights, to a more structural Marxist assessment of the relationship of law to economics and other social spheres. Biographical sketch. Little is known about Pashukanis prior to the 1917 revolution. We do know that he studied at the University of St. Petersburg before World War I, and that he completed his legal training at the University of Munich. He subsequently returned to post-revolutionary Russia, became a Bolshevik, served as a judge in the Moscow area, and in the early 1920s he conducted legal advice for the People's Commissariat of Foreign Affairs. In 1924, Pashukanis wrote that what is probably his most influential piece, The General Theory of Law and Marxism, and in the second edition of 1926, stated that this work was not to be seen as a final product, but aimed rather at, quote, self-clarification, in hopes of adding, quote, stimulus and material for further discussion, end quote. A third edition was printed in 1927. Pashukanis's direct involvement in shaping the legal culture of post-revolutionary Russia, particularly from the 1920s through the mid-1930s, was extensive and had a significant impact. From 1924 to 30, Pashukanis assumed a number of important positions in the Soviet political and academic structure. These posts included membership in Piotr I, Stuchka's section of Law and State, and the Institute of Soviet Construction, as well as his tenure as head of the subsection of the Institute of Soviet Construction on the General Theory of Law and State. Under the auspices of the Section of Law and State, Pashukanis, in 1925, co-edited Revolution of the Law, a collection of papers on Lenin's understanding of Marxism and law. That same year, he joined the law faculty at Moscow State University and the Institute of Red Professors. Pashukanis was to become a prolific writer on various aspects of law and Marxism. As such, he was involved with various editorial responsibilities of scholarly journals, including his position as founding editor of Revolution and Culture, which dealt with the cultural aspects of the October Revolution. By 1930, Pashukanis' influence was pronounced in legal circles, and his commodity exchange theory of law was dominant in the law curriculum. Within the Communist Academy, two wings of the commodity exchange perspective were to emerge by the late 1920s, the more moderate wing, initiated by Stuchka, and the more radical wing represented by Pashukanis. The tension between the two factions led to a great deal of discussion about the function of law in the transitional period. Stuchka was Pashukanis' main rival in this analysis, but outside of the Communist Academy, A.A. Piankovsky, a member of the competing Institute of Soviet Law, was also a critic. From 1927 to the early 1930s, the exchange between Stuchka and Pashukanis was to persuade the latter that some of his early statements made in the general theory of law and Marxism should be qualified to include class dimensions in the overall analysis. In June 1930, the 16th Party Congress saw some of the disagreements between Pashukanis and his critics come to a head already. In 1929, Stalin, as General Secretary, had warned that the class struggle had reached a critical level and that the dictatorship of the proletariat needed consolidation and strengthening. Furthermore, this was the time of the first five-year plan, and forced collectivization and massive industrialization was occurring. The 16th Congress, ipso facto, rejected the idea of the gradual withering away of state and law. At this Congress, Stalin was poignant. Quote, "We are for the withering away of the state, while at the same time we stand for strengthening the dictatorship of the proletariat, which represents the most potent and mighty authority of all the state authorities that have existed down to this time." End quote. It was at this moment, according to Berna and Charlotte, that the commodity exchange theory of law was decisively undermined, preventing the commodity exchange theory of law from contributing to an understanding of the transitional dynamics of law towards the, quote, higher order. The tide of criticism was hereafter to relentlessly grow. Pashukanis subsequently qualified his position, especially in his 1932 article called The Marxist Theory of Law and State, where he argued that, quote, "Law cannot be understood unless we consider law as the basic form of the policy of the ruling class," end quote, and that the, quote, "particular role of the legal superstructure is enormous in the transitional period, when its active and conscious influence upon production and other social relationships assumes exceptional significance," end quote. Meanwhile, the 17th Party Congress of 1934 called for greater legal formalism, a position directly opposed to Pashukanis' and others, such as Nikolai Krylenko's views of legal nihilism. In 1936, Pashukanis further recanted and said, quote, "We also insisted that Soviet law must enjoy the maximum mobility and flexibility during the period of full-scale socialist offensive," end quote. We recall that in his 1926 and 1927 editions of the General Theory of Law and Marxism, he had already begun his rethinking. Nevertheless, his ideas were still too inconsistent with the developing dictatorship of the proletariat and the demands of the transitional period, so said Stalin through his spokesperson Vyshinsky, Procurator General of the Soviets. Procurator General of the Soviets. In January 1937, Pashukanis was arrested and made to, quote, disappear. Vyshinsky then assumed the role of further dismantling and vilifying Pashukanis' work and of rebuilding the Soviet legal system according to the ascending notion of Soviet law, the law of the transitional period. Writings: Marx and the Commodity Exchange Theory of Law. From 1924 to 1936, Pashukanis produced a number of works on Marxism and law. It is remarkable that Pashukanis was so active in both theoretical work and practice. During this time, Pashukanis was simultaneously refocusing the law school curriculum, actively contributing to building the new order, and refining his analysis of Marxism and law, particularly as it led to the eventual withering away of the state and law. His contributions in various scholarly debates during the post-1917 years were squarely centered on the meaning of law in the new Soviet society. But the key work by Pashukanis was his 1924 book-length manuscript, The General Theory of Law and Marxism. This significant comprehensive statement on Marxist law detailed his commodity exchange perspective. While the theory was to undergo some modifications in the second and third printing of the General Theory, it nonetheless maintained its central focus on the development of the form of law that emerges in the capitalist mode of production. The theory attempts to explain how the core of law can be traced to the exchange of commodities in the competitive laissez-faire marketplace. It draws inspiration from the first 100 pages of Marx's Capital, where the notion of fetishism of commodities is discussed. Note, Marx's position draws from Hegel. Pashukanis indicated that a homology existed between the development of the commodity and legal form, and that this development occurred, quote, behind people's backs, end quote, regardless of class standing. Capital logic, he contended, produces such abstractions as the juridic subject, the, quote, reasonable man in law, end quote, and principles such as the, quote, due process clause, end quote, and the, quote, equivalence principle, end quote, both articulated in the 14th Amendment to the United States Constitution. Capital logic was also to find its way into various slogans verbalized during revolutions around the world, which were subsequently given, quote, idealized expression, end quote, in the various, quote, declarations of independence, end quote. Let us summarize Pashukanis' theory as developed in his initial publication of 1924. Following this, we will look at some of the critiques and the impact of this perspective. Theory: Commodity exchange perspective. The legal form, Pashukanis argued, developed directly out of the exchange of commodities in the competitive capitalist marketplace, and in a parallel fashion, homologous to the commodity form. Let us briefly summarize. A commodity is constituted by two aspects: the commodity's use value and the commodity's exchange value. The use value of a commodity can, in turn, be seen as incorporating two elements: an unequal amount of labor in its production and the unequal amount of benefit that it brings. Use value thus incorporates differences. Whenever we produce for direct use, we have products and not commodities. In competitive capitalism, however, objects produced in exchange take on the form of commodities. When two commodity owners meet at the marketplace to exchange commodities, the initial use value undergoes a change to a, quote, exchange value. Exchange value reflects a ratio of exchange. One commodity is exchanged for another in a specific quantitative ratio. 2 gallons of milk, for example, could be exchanged for 1 pound of butter. This is a mathematical relationship of equivalence. 2 gallons of milk are equal to 1 pound of butter. Inherent differences in the use value are now replaced by a ratio of exchange. What began as a qualitative relationship, e.g., inherent differences in the use values, is, through commodity exchange, translated into a quantitative relationship. Further, money becomes the, quote, universal equivalent. $2 can purchase either 2 gallons of milk or 1 pound of butter. As a masking has taken place, quote, the memory of use value, end quote, Marx tells us, quote, as distinct from exchange value, has become entirely extinguished in this incarnation of pure exchange value." End quote. What has disappeared from consciousness are the inherent differences, now replaced by their representative. Quality has been changed into quantity, substance into form, and money is now worshipped as the universal equivalent. This is the process of the fetishism of commodities. It is also known as the law of equivalence, or capital logic, and it occurs, quote, "behind people's backs," end quote. But this process is also the basis of the development of the legal form according to Pashukanis. The development of the abstraction, the juridic subject, the, quote, "reasonable man in law," end quote, and notions of formal equality have their origins in the process of the exchange of commodities. The commodity exchangers enter the marketplace as inherently different from others, i.e., they have different interests, wants, needs, and desires. Commodity exchangers are similar to the notion of use value, reflecting inherent differences. But two inherently different commodity exchangers enter an exchange situation in a definite relationship. At the exact moment of exchange, three specific phenomenal forms appear. First, the two commodity owners enter a relationship of equality. Each recognizes the other as an equal in the very moment of exchange. Even as there are inherent differences between the two, at the moment of exchange there is equivalence. Second, at this moment there is also recognition of free will. Each of the parties sees the other as freely exchanging a commodity. Finally, each recognizes the other as a rightful owner of the commodity that is being exchanged. The constant exchange of commodities in the marketplace produces these three phenomenal forms: the notion of equality, free will, and the proprietorship interests. The idea of the bearer of rights develops out of this instance, and lawyers have provided, quote, "idealized expression," end quote, for these emergent forms. The juridic subject as the bearer of these abstract rights is now similar to the notion of, quote, "exchange value," end quote. A person has been transformed into the reasonable man in law equivalent to other juridic subjects. As Pashukanis has said, quote, "the legal subject assumes the significance of a mathematical point, a center in which a certain sum of rights is concentrated," end quote. The equivalence principle derived from capital logic is therefore elevated to the heavens as a sacred right and incorporated in many emerging constitutions that resulted from social transformations. In some, just as the commodity was transformed from use value to exchange value, so too is the person. Differences have been brought under the relationship of equivalence. Pushed away from consciousness is not only the unique and idiosyncratic, but also the historical production of the commodity and the person. Along with the abstract development of law in the juridic subject, there appeared the need for formalistic contracts. For Pashukanis, quote, "in the logical system of legal concepts, the contract is only one of the forms of transaction in general, i.e., one of the methods of concrete expression of the will, with whose aid the subject acts upon the legal sphere around him." End quote. Quote, "outside contract," end quote, Pashukanis continues, quote, "the very concepts of subject and will exist only as lifeless abstractions in the legal sense," end quote. In the U.S. Constitution, the equivalence principle can be found in the 14th Amendment's, quote, "equal protection clause," end quote, which argues that equally situated should be equally treated. The juridic subject becomes a universal equivalent. Law finds its own legitimation principle within the logic of equivalent exchange, and the, quote, "rule of law" is elevated to the heavens. Both rich and poor are brought within its purview and are formally equal before the law. By bringing diverse subjects under a similar measure, many critics in the 1980s, following Pashukanis' logic, argued that the result was repressive formalism. This had already been anticipated much earlier in the work of Max Weber. Pashukanis' insights into the development of the legal form outlined in 1924 were subsequently questioned. Pashukanis was to make some changes, but his essential position concerning the homology between the legal form and the commodity form remained intact to the end. Additionally, Pashukanis argued that commodity exchange must be altered if these fetishisms were to be transformed, and that only in the, quote, higher forms, end quote, of communism would the need for the state, law, and the juridic subject disappear. During the transitional period, he wrote, quote, human relationships will for a time involuntarily be limited by the, quote, narrow horizons of bourgeois law, end quote, end quote. Desirable, therefore, following Marx and Lenin, was the movement towards the higher forms, but it was this very question that was strongly debated during the, quote, transitional period of the dictatorship of the proletariat, especially during the creative and fertile years between 1917 and 1937. What was to become of Soviet law during this period? Law, morality, crime, and punishment. Pashukanis' theory of commodity exchange and the development of equivalent exchange capital logic find their expression in notions of morality, crime, and punishment. For Pashukanis, ideas on morality are derived from the constructed fetishisms of rationally calculating egoists and from the development of the abstract concept of social equality. As he tells it, quote, if moral personality is nothing other than the subject of commodity production, then moral law must reveal itself as the rule of exchange between commodity owners, end quote. Notions of justice are, therefore, derivative from commodity exchange. Similarly, with the violation of law, equivalent exchange materializes itself in the form of equivalent punishment. It is only at a certain stage of economic development where equivalent exchange dominates that we also find punishments fully expressed and articulated in the form of equivalent exchange. Ancient law, Pashukanis goes on to say, knew only collective responsibility. Bourgeois capitalist law, on the other hand, invents the notion of individual responsibility and liability and a, quote, gradation of liability, end quote. The equivalence principle becomes dominant. Quote, deprivation of freedom for a definite term previously indicated in the judgment of the court is the specific form in which modern, that is, bourgeois capitalist criminal law, realizes the basis of equivalent retribution, end quote. Pashukanis explains that there is a difference between retribution and social defense as responses to crime. Social defense would go beyond the abstract equivalence principles of the former inasmuch as social defense would require a clear quote, social defense would, quote, require a clear description of symptoms characterizing a socially dangerous condition and the development of those methods which must necessarily be applied in each given case for social defense. End quote. In other words, for Pashukanis, I think I read that wrong. The latter would go beyond, social defense would go beyond the abstract equivalence principles of the retribution, inasmuch as, quote, it would require a clear description of symptoms characterizing a socially dangerous condition and the development of those methods which must necessarily be applied in each given case for social defense, end quote. In other words, for Pashukanis, the social defense approach must return to the notion of the law of differences, not equivalences, in dealing with those who break the law. He concludes his general treatise on Marxism and law by stating that abstract notions of crime and punishment will only begin to disappear when the, quote, general withering away of the legal superstructures begins, end quote. His tautological conclusion is that to the extent that these categories are disappearing, quote, narrow horizons of bourgeois law are disappearing, end quote. Historical examination indicates that Lenin's early statements that only, quote, excesses, end quote, will exist in the higher form and that some type of social defense is the initial ideal response under the dictatorship of the proletariat gradually gave way by the mid-1930s to Stalin's and Vyshinsky's return to retribution theory. By this time, both men's writings had already generated much momentum for the return of legal formalism. Critiques and revisions. Pashukanis from the mid-1920s to 1936 was to be attacked for his position in the development of law on a number of fronts. It should be mentioned that prior to 1919, there was no lively discussion or debate on Marxist law in Russia. With the revolution came the dismantling of the czarist form of law in courts. Certainly a vacuum existed as to the question of what form law should take during the transitional period. Key critical theorists who provided the basis of revisions by Pashukanis were Peter Stuchka, Nikolai Krylenko, and Andrei Vyshinsky. Stuchka, a significant figure in the emerging Soviet society, criticized Pashukanis for his neglect of class in the development of law during the transitional period. 3 years prior to Pashukanis' 1924 manuscript, Stuchka had published The Revolutionary Role of Law and State, which provided much discussion on Marxist law. While Stuchka praised Pashukanis' work in the book's third edition, he nevertheless disagreed with the exclusion of class in Pashukanis' analysis of Marxist law. For Stuchka, the transitional period demanded a Soviet law which would aid in the eventual transformation into the classless society of communism. For Pashukanis, on the other hand, Soviet law was inherently a continuation of the previous bourgeois law. It has been suggested by Charlotte, Maggs, and Berna that Stuchka provided the logic necessary to support a Soviet legal system not only for the transitional period but for some time thereafter. In fact, for these authors, Stuchka, albeit inadvertently, supplied the logic that would undermine the notion of the withering away of law. This logic was later to contribute to Stalin's and Vyshinsky's articulations of Soviet law. But Stuchka's position also suggested a simplification of the legal process. Regrettably, Stuchka died from natural causes in 1932 at a time when his voice could have contributed to further productive debates about the nature of Soviet law. Whereas Stuchka's position on the law's development was focused on the primacy of superstructural practices, Pashukanis' position was focused on the workings of the, quote, base and the Marxian conceptualization of the base superstructure metaphor. Pashukanis had written that, quote, Comrade Stuchka correctly identified the problem of law as a problem of a social relationship, but instead of beginning to search for the specific social objectivity of the relationship, Stuchka returned to the usual and formal definition. Law figures not as a specific social relationship, but as with all relationships in general, as a system of relations which corresponds to the interests of the ruling class and which protects the ruling class with organized force. End quote, Pashukanis. Pashukanis goes on to state that Stuchka's definition of law, quote, was tuned to the needs of the practicing lawyer. It shows the empirical limit which history always places upon legal logic, but it does not reveal the deep roots of this logic itself. This definition reveals the class content included in legal forms, but this definition does not explain to us why this content adopts such a form. End quote. The position Pashukanis took in 1924 was that understanding class relationships alone does not go to the deeper sources of the particular legal form that develops. However, it was just this position that was the focus of the attacks that culminated in Pashukanis' purge in 1937. Pashukanis did, however, later qualify his central argument in the commodity exchange perspective. We find, for example, in his 1927 article, The Marxist Theory of Law and the Construction of Socialism, a concession to Stuchka's criticism. Pashukanis states emphatically, I readily agree that my 1924 essay in many respects needs further development and perhaps reworking. A whole series of problems could not be covered in the book, and indeed, at that time, simply did not come within the author's field of vision. Such, for example, is the problem of the law of the transitional period or Soviet law fully posed by Stuchka, which is among his outstanding contributions to the theory of law. Pashukanis, 1927. But Pashukanis immediately follows with, quote, I did not view the process of the withering away of law as a, quote, direct transition from bourgeois law to non-law, end quote. And he dismisses Stuchka's critique of, quote, economism, end quote, against him. Here Pashukanis reminds Stuchka that the, quote, economic subjects as exchangers end quote, as exchangers of commodities and the social division of labor are, quote, facts, end quote, and that they are not inherently connected with the wishes of the state. These, quote, facts, for Pashukanis, quote, contain the basic and principal prerequisites for a legal relationship, end quote. Pashukanis does, however, give credit to Stuchka for noting the importance of state power in the transition from one form of the mode of production to another. Concerning this, he tells us that Stuchka is, quote, absolutely right, end quote. In 1932, we see Pashukanis returning to this question in his article, The Marxist Theory of State and Law. Here, Pashukanis notes the significance of the independent influences on law by superstructural practices. Quote, we cannot deny the real existence of the legal superstructure, i.e. of relationships formulated and consolidated by the conscious will of the ruling class, end quote. It seems that at this point Pashukanis was developing a new, more integrated form of his commodity exchange perspective, for he goes on to say, quote, but to study law only as relationships of production and exchange means to confuse law with economics, to retard the understanding of the reciprocal action of the legal structure and the legal structure's active role. At the same time, as production relations are imposed on people regardless of people's will, not the people, just people's will, legal relationships are impossible without the participation of the conscious will of the ruling class, end quote. Pashukanis, 1932. Here, Pashukanis anticipates many of the revisionist theories later developed by Louis Althusser and Nikos Poulantzas from the late 1960s to the late 1970s. The emerging notion, contrary to the dominant form of instrumental and class-oriented Marxism in the 1960s, was that a number of relatively autonomous spheres existed, the economic, political, ideological, and juridical, and appeared historically in relatively stabilized articulations, producing the actual substance of law itself. At different historical junctures, one of these social spheres may indeed be the more dominant. Pashukanis seemed already to be acknowledging this with his comment in this same 1932 article when he stated, quote, a legal relationship is a form of production relations because the active influence of the class organization of the ruling class transforms the factual relationship into a legal relationship, gives it a quality, and thus includes it in the construction of the legal superstructure, end quote. Pashukanis is indicating the interconnected nature of the various spheres of influence, where one may be the more dominant. For example, he states that, quote, the revolutionary role of the legal superstructure is enormous in the transitional period when its active and conscious influence upon production and other social relationships assumes exceptional significance. Soviet law, like any law, will cease to exist if it is not applied, end quote. But Pashukanis' various reconceptualizations fell short of keeping his attackers at bay. He still maintained that Soviet law was to be, quote, seen exclusively as a legacy of class society imposed on the proletariat and which haunts it until the second phase of communism, end quote. Pashukanis continued with this thesis in a 1935 work co-authored with L. La Ginsberg, a course on Soviet economic law, where Pashukanis once again notes the, quote, class nature, end quote, of Soviet economic law. Pashukanis even advocates in a 1936 article entitled, quote, State and Law Under Socialism, end quote, that Soviet law must be given, quote, maximum mobility and flexibility during the period of full-scale socialist offensive, end quote. At this point, there is a certain irony at work. Vyshinsky during this time was suggesting a re-establishment of formal law of social stability and argued for blending socialist and revolutionary legality. Krylenko, on the other hand, as noted above, had been debating Vyshinsky and was advocating the idea of law as analogy and for the simplification of law. Stuchka, who died in 1932, contributed in many ways to this debate, providing much support for Vyshinsky's call for formalism in law. Stuchka, for example, believed that formalism and the adversary process were highly cultural. Stuchka, for example, believed that formalism and the adversary process were high cultural accomplishments that had to be maintained, Pashukanis' position shifted from his initial strong argument for the exclusive analysis of relations of exchange in the development of law and for the withering away of the state and law to his revised position of the early and mid-1930s. This latter stance was one in which he advocated state intervention in the social formation with a recognition that the law's roots still resided in commodity exchange. This reconsideration added a rich dimension to the debate. Pashukanis was at odds with Vyshinsky and Stuchka, but had some sympathy for Krylenko's position. Nonetheless, Pashukanis, who in the mid-1930s seemed to be persuaded to accept some of Soviet law during the transitional period to the higher forms, must have seen Krylenko's position as being out of touch with the emerging society. Perhaps Pashukanis' downfall had to do with the fact that he was unable to provide convincing analysis of how law should look during the transitional period in order for the higher form to develop from it. It seems that a dialectical position was required which advocated a form of Soviet law during the transitional period that embedded within it sufficient tension for the gradual transition to the withering away of the law itself. This would have also called for discernment in how to organize the productive and exchange spheres in such a way that the dialectical tension would aid in the transition to the higher form. Pashukanis was already suggesting something along these lines in the mid-1930s, indicating that he was indeed working on a more fully developed theory. This insight is indicated by his 1936 article in which he suggested a reciprocal effect between the base and superstructure and the desirability for guidance from the superstructure in the form of Soviet law. Krylenko's effect on Pashukanis emerged out of the former's increasingly hostile debates with the rising Vyshinsky during the early 1930s. As an old Bolshevik and as Commissar of Justice until his arrest in January 1938, Krylenko's view of law was considered one of the more extreme, a perspective identified as legal nihilism. Whereas Krylenko advocated the simplification of law, Vyshinsky ironically advocated legal formalism as a way of providing stability in society. In retort to a proposed draft of the criminal law offered by Krylenko in 1935 with the thrust that judges should merely orient themselves to law, not be bound by law, Vyshinsky responded that it went against Stalin's earlier speech, which advocated stricter adherence to law. During the next 2 years, this public debate continued, and Vyshinsky was accused by Krylenko of reinventing legal retribution, a bourgeois form of punishment for dealing with offenders. Vyshinsky, who was appointed as the Procurator General of the USSR in 1935, continued his purging of rival theorists, Pashukanis, Stuchka in absentia, and Krylenko. No public trial took place for Pashukanis, nor were formal charges initially made. However, subsequently to his disappearance, he was attacked by Vyshinsky, quote, "The pseudo-scientific positions of Pashukanis and his group in the field of law have been completely shaped by the counter-revolutionary, quote, theories of Trotskyism and the rightists, in particular by the anti-Leninist views of Bukharin," end quote. Vyshinsky, 1937. In 1937, Stuchka was cited as, quote, "a propagator of harmful ideology and a deliberate wrecker in the field of jurisprudence," end quote. Vyshinsky, in 1938, called Stuchka the advocate of, quote, "the Bukharinist perversions of Marxism-Leninism," end quote. As for Krylenko, the charge was, quote, "the uncritical repeating of the ideas of Pashukanis," end quote. Krylenko was arrested in early 1938, 1 year after Pashukanis' arrest, and purged. According to one source, quote, "he was accused of ties with a right-wing anti-Soviet organization that was supposedly headed by Bukharin, of having created a wreckers organization and agencies of the justice system, and having carried out subversive activities, and of having personally recruited 30 people," end quote. At the end of the 20-minute trial on July 29, 1938, Krylenko was sentenced to be shot. So there ended a social experiment, an attempt at revolutionary change from below. The rich debate concerning law during the transitional period was answered by the purges of 1937 to 1938. Stalin, aided by Vyshinsky's rhetoric and revisionism of law, prevailed, placing a lid on the possibilities that were embedded in the revolution of 1917 and experiments started in 1917 with the fertile possibilities of liberating human potential was delivered a death blow. Legacy, historical lessons often withered away. What possible benefit can be gained in revisiting Pashukanis? To have yet a newer edition of his works published? Haven't the historical lessons already been learned? Are would-be revolutionaries so well acquainted with the notion of the dialectics of struggle that nothing can be gained by reviewing Pashukanis' work and the context for its development and subsequent dismissal? What value do we place on the meticulous and clear-headed research and writings of those such as Berna and Charlotte, Hunt and Solomon, dealing with those critical years in post-revolutionary Russia? Pashukanis' work is significant on a number of levels. In the late 1970s and early 1980s, a number of theorists teased out the various implications of his early version of the commodity exchange theory of law. By the mid-1980s, there was a decisive switch in Marxist analysis in the social sciences away from instrumental Marxism and towards structural Marxism that was in many ways informed either directly or indirectly by Pashukanis' work. The structural form of Marxism indicates the interplay of relatively autonomous spheres, the economic, political, ideological, and juridical, which can be studied in their historical manifestation in terms of relatively stable configurations. It is the active intervention by the juridic sphere in other social spheres through such mechanisms as, quote, interest balancing, end quote, that the subject of late capitalism is no longer perceived in a unitary manner. Rather, there has been a historical transformation from status to contract and increasingly back to status. One's rights and duties become increasingly connected with one's position, one's status in the social formation, i.e. free citizen, prisoner, juvenile, mentally ill, welfare recipient, unionized worker, soldier. Given this relative stability, phenomenon must be seen as overdetermined, and it may very well be that Pashukanis' initial 1924 statement of the commodity exchange perspective was congruous with the 19th century laissez-faire forms of capitalism, but 20th century political economy, with its tendencies towards, quote, legitimation crises, Habermas, brought with it greater intervention by the state, the superstructure. Subsequent revisions by Pashukanis of his 1924 statement, especially in response to the critiques of Stuchka, seem to indicate that Pashukanis was indeed developing a more sophisticated model that would take into account capital logic, class interests, superstructural practices, and the reciprocal effects among these. The full development of this reciprocity was not theorized until the mid-1980s. The contemporary era of critical social science research no longer privileges dogmatic forms of Marxism. Certainly, there is the old guard protecting the sacred tablets of truth, but more contemporary works, such as those of Laclau and Mouffe, and Laclau... Sorry, it's like saying different books by them. But more contemporary works, such as those of Laclau and Mouffe, question some of the concepts of Marxism interpreted by critical social scientists. The question of the category of, quote, working class itself has been central. Is there such a thing as a homogeneous working class? Laclau questions whether it is still a useful concept because class in late capitalism does not reflect the variety of factions in existence. Similarly, Butler has examined the recent question of gender and has indicated its inherent instability. Recent research is beginning to examine the question of the intersection of class, gender, and race. Doubtless, the old guard attempts at all costs to hold on to this sacred concept of class, but contemporary research has indicated a much more dynamic form of political economy which necessitates new ways of thinking about law. In fact, the very quote, dislocations, end quote, structural undecidabilities, end quote, in existence in postmodern society are opportunities for the development of new, more humanistic articulations. Consequently, Pashukanis' work is still central in this creative time of reevaluation, refinement, deletion, and the development of law. Connected to this are some of the inexcusable and deplorable contemporary forms of, quote, praxis, end quote, that are not rooted in historical lessons. We only have to examine the Cuban experience and post-revolutionary Nicaragua under the Sandinistas to see both the good and bad in activism. Pashukanis' work shows us the complex forces that exist at the time of revolutions. During revolutions, creative possibilities, good and bad, emerge. However, those activists who are not sensitive to historical examinations of these vacuums can easily fall into Stalinist forms of expression, goddamn right about that, or even become, as Marx himself had warned with his and Gramsci's notion of hegemony, their own gravediggers, and overzealous would-be reformers unguided by some notion of fairness and understandings of historical specificities outside of their own ends justify the means rhetoric can quickly engage in negative forms such as political correctness, reversal of hierarchies, Schmarxism, dogmatic Marxism, moral hate, quote, hate politics, end quote, and exorcism. I like that whole bit. I don't know what parts of it I agree with or not, but I like it. I'm going to read it again. And overzealous would-be reformers, unguided by some notion of fairness and understanding of historical specificities, outside of their own ends justify the means rhetoric, can quickly engage in negative forms such as political correctness, reversal of hierarchies, Schmarxism, dogmatic Marxism, moral hate, quote, hate politics, end quote, and exorcism. Pashukanis' work has also sensitized us to the notion of, quote, repressive formalism, end quote. This idea, which demands scrutiny of abstract principles that on the face seem fair, indicates that new notions of fairness need to be researched, developed, and instituted. Marx's offering of the notion, quote, from each according to his ability to each according to his needs, end quote, is still relevant today. Here, rather than, quote, formal equality, end quote, rooted in capital logic, new operative principles must be developed that recognize the uniqueness of the human being. See, for example, Laclau and Mouffe's privileging of the, quote, logic of difference, end quote, rather than the, quote, logic of equivalence, end quote. Berna and Charlotte have also offered some keen observations concerning revolutionary change. First, they note that even if a dictatorship of the proletariat is necessary, Marx and Lenin had argued that it should be restricted in duration and extent. Second, societal elements, structures, and institutions developed within the transitional phase, quote, must dialectically contain the capacity for self-transformation, end quote. Chaos theory's conceptualization of, quote, dissipative structures, end quote, is an especially appropriate concept here. See also Unger's transformative agenda, which looks very much like far from equilibrium conditions, replete with emerging dissipative structures advocated by chaos theorists. And third, the form of social relationships themselves must be transformed. This process is informed by historical analysis. This has everything to do with the mode of production and political economy. Pashukanis had already informed us that, quote, a society which is compelled to preserve equivalent exchange between labor expenditure and compensation in a form even remotely resembling the exchange of commodity values will be compelled also to preserve the form of law, end quote. From my own analysis above, I would add, as a fourth point, being aware and sensitive to the dialectics of struggle as a necessary component to an emancipatory form of transpraxis. Pashukanis' work certainly provides much context for understanding these central concerns and social struggles. Conclusion. This republication of Pashukanis' work on law at the turn of the millennium is timely. It beckons us to be sensitive to historical struggles and their outcomes. It provides us with an understanding of how social transformations can take unintended directions with the emergence of Stalin-like figures, but it also indicates the creative potential that can provide the basis of a new, more humane order. The more recent Russian Revolution of 1989 to 1990 still awaits the visionary who will come forth in a time of turmoil to pronounce a thesis equivalent to that of Pashukanis's.